July 2nd, 1890. Congress passed a law that was supposed to end the robber barons. The Sherman Antitrust Act passed the Senate 51-1. It passed the House 242-0. The most unanimous legislative response to concentrated economic power in American history. And for its first 12 years, it was used almost exclusively against the workers the robber barons had exploited, not against the robber barons themselves. This is the story of the Sherman Antitrust Act, the law that looked like a hammer and turned out to be a key. The Sherman Antitrust Act was passed in response to strong and widespread political pressure to deal with what politicians called the trust problem. By 1888, trusts dominated virtually every major industry in America. The Sugar Trust controlled 98% of sugar refining. The Beef Trust controlled the meatpacking industry. The Tobacco Trust, the Whiskey Trust, the Cordage Trust, and most visibly, Rockefeller's Standard Oil. Controlling 90% of American oil refining through secret railroad rebates and the systematic destruction of every competitor. Consumers, workers, farmers, and other suppliers were directly hurt monetarily as a result of the monopolizations. Even more important, perhaps, was that the trusts fanned into renewed flame a traditional U.S. fear and hatred of unchecked power, whether political or economic, and particularly of monopolies that ended or threatened equal opportunity for all businesses. The public demanded action. Congress delivered a bill. President Benjamin Harrison signed it into law on July 2nd, 1890. The Sherman Antitrust Act prohibited any combination in restraint of trade. It made monopolies illegal. It gave the government power to break up any organization that suppressed competition. On paper, it was everything the public had demanded. In practice, the Sherman Act was a paper tiger. For the first 12 years of its existence, United States courts routinely sided with business when any enforcement of the act was attempted. The most devastating early blow came in 1895. The American Sugar Refining Company controlled 98% of the nation's sugar refining capacity. The government sued under the Sherman Act. The Supreme Court refused to dissolve it. In the infamous E.C. Knight case of 1895, the court refused to apply the law against the Sugar Trust. The court held that the Sherman Act concerned interstate commerce and not manufacturing. Manufacturing was not commerce. So a company could monopolize an entire industry, as long as the monopoly happened in a factory rather than in trade. The loophole was enormous. And while the courts were refusing to apply the Sherman Act against corporations, they were using it enthusiastically against workers. Of the 13 decisions invoking antitrust law between 1890 and 1897, 12 involved labor unions. 12 out of 13. The law passed to protect ordinary Americans from the robber barons was being used to crush the strikes of the workers the robber barons employed. The architecture of 1890 and 2008 was identical. The law looked like reform. It functioned as protection. Everything changed in September 1901. President William McKinley was assassinated, and Theodore Roosevelt, 42 years old, the youngest president in American history, took office. Roosevelt was not anti-business. He believed there were good trusts and bad trusts, but he believed the courts could not be relied on to break up the bad ones. Little progress was made against trusts until Roosevelt took power. He was as concerned as the public over the continued growth of powerful trusts. Philander C. Knox, Roosevelt's Attorney General, initiated 44 antitrust suits during the Roosevelt administration. His first target was the Northern Securities Company, a J.P. Morgan holding company that controlled multiple railroad lines across the American Northwest. Morgan went to see Roosevelt personally. He reportedly told the president, "If we have done anything wrong, send your man to my man and they can fix it up." Roosevelt declined. The Supreme Court ruled 5-4 that Northern Securities violated the Sherman Act. It was dissolved. Morgan was furious, and Roosevelt had his precedent. While Roosevelt's lawyers were building their antitrust cases, a journalist was doing something the law had failed to do for 20 years, exposing Standard Oil to the American public. Ida Tarbell was the daughter of an oil man whose business had been destroyed by Rockefeller's practices. She spent 5 years investigating Standard Oil for McClure's magazine, interviewing former employees, reviewing court documents, obtaining internal communications. Between 1902 and 1904, she published 19 articles detailing exactly how Standard Oil had achieved its monopoly: the secret railroad rebates, the industrial espionage, the systematic destruction of competitors, the corruption of state legislators. Her work reached millions of readers. Public outrage built to a level that made legal action politically unavoidable. In 1906, the U.S. government brought suit against Standard Oil under the Sherman Antitrust Act. It would take 5 years. May 15, 1911. The U.S. Supreme Court unanimously affirmed a lower court's ruling that the monolithic Standard Oil Trust represented an illegal monopoly and would have to be broken apart. Its decision hinged on the unreasonable nature of Standard Oil's anti-competitive efforts, which ran afoul of the 1890 Sherman Antitrust Act. The New Jersey company was ordered to divest itself of its major holdings, 33 companies in all. Standard Oil was broken into 33 separate companies. It was the largest corporate breakup in American history. The public celebrated. Rockefeller, who received shares in every successor company, became even wealthier as the newly competitive market drove up the value of each individual company. He had been broken up into pieces that were collectively worth more than the whole. The law had worked, and in doing so, had made the man it targeted richer than he had ever been. 2 of those 33 successor companies eventually recombined. You know them today as ExxonMobil and Chevron. The Standard Oil breakup exposed what the Sherman Act still couldn't do. It had no specific list of illegal practices. It relied on courts to interpret what unreasonable meant, and it still had no explicit protection for labor unions. In 1914, Congress passed the Clayton Antitrust Act, specifically to close the loopholes. The Clayton Act named specific illegal practices: predatory pricing, exclusive dealing contracts, interlocking directorates, where the same people sat on the boards of competing companies, and it explicitly exempted labor unions from antitrust prosecution. The Federal Trade Commission was created the same year, a permanent government body to monitor and enforce competition law. The architecture of American antitrust regulation was finally complete, after millions of workers had been crushed by the law that was supposed to protect them. Here is what the Sherman Antitrust Act actually achieved. It took 21 years to break up Standard Oil. Standard Oil's successor companies recombined into corporations that are today among the largest on earth. Rockefeller got richer from the breakup than he had been from the monopoly. The law that was supposed to end the robber barons became the framework that the robber barons' successors used to navigate regulation for the next century. Today, the same arguments are being made about technology companies that were made about Standard Oil in 1890. Monopoly, predatory pricing, the suppression of competition, the capture of regulatory bodies. The names change, the industries change, the architecture never changes. The vault gets richer, and somewhere, always somewhere, something else is burning. Next video. The Federal Trade Commission, the body created to enforce the Sherman Act. Who actually runs it? Who it actually serves? And why the most important antitrust cases of the last 50 years ended the same way the Sherman Act did in 1895. Subscribe to Vault and Ruin. We go where the money went.